What are the biggest reasons for a denial in an L-1 visa? Hey everybody, this is Charles Rather, Managing Partner at AmLaw Group, where we make your transition to the U.S. as effective, efficient, and fast as possible. And today I wanted to talk about reasons for getting an L-1 denial. And in fact, I want to talk about probably the top two reasons, because if I had to make a generalization, I would say 90% of the denials come down to two issues. And here are the following two issues and how you can try to avoid it. Issue number two, and here I should say that I don't think there's a big difference between issue one and issue two. They're actually quite similar. But I would say the item number two, second most common reason for denial, is the applicant was not able to prove that he or she had or maintained an executive position overseas. Now, when I say executive, I'm also referring to managerial. If you're into the wonky details of an L1, you could be a manager and you could be an executive to get the L1, but just for simplicity's sake, I'll refer to all of that as being an executive. So second most common reason for denial is inability of the applicant to show he or she had an executive position in their overseas company prior to coming here, or managerial, or whatever, what may be the case. And how do you avoid that? Well, it's true, there's not a whole lot you can do. I mean, you have your experience, you have your work, there's not much we can do after the fact. But certainly we want to present everything in the most positive light. But how do you avoid that conclusion, the officer making that conclusion? Well, we need to show what your job responsibilities were. We need to show that you had extensive, especially if you're an executive, of course, extensive job responsibilities and oversight of the operations of the company, oversight of personnel, ability to hire and fire personnel, ability to oversee various departments underneath you. So those are very important job descriptions or duties that they will be looking at. Another thing is they'll look at how many subordinates you have. If you've got a relatively small overseas company and you have, say, less than 8 subordinates, I would say it's going to be a challenge to get past this hurdle. We've had clients in the past, but this was years ago. They might have only had 3 or 4 employees overseas, and it wasn't a problem. From our most recent experience, I would say you've got to have probably 8 subordinates or more at your overseas company. Again, this is not a number that's set in stone, that's in the law. This is just our experience doing this for 15 years, what the government is looking for. Now, if these are more highly skilled, very professional subordinates, let's say your subordinates are all doctors or, I don't know, accountants or other licensed professionals, then that requirement to have the 8 or more employees is not as important. You could have fewer, because if you're overseeing more highly qualified, more professional, licensed subordinates, then that requirement is not as high. The other, item number one, I should say, the most common reason our clients probably get a denial for L1, and overall, more than 90% of our clients get approved, maybe 95, I don't know the number. But the number one reason I would say is the inability to show that there will be a necessity for an executive here in the US at the new company. Now, if you are acquiring an existing business in the US, then that analysis is a little different. They're going to look at, as of the day of the filing, how many employees you have, what will be your job duties, what's the org chart, the structure of the employees, and they're going to look at what everything is as of the day you file. So you need to make sure, I would say, minimum 8 employees at the US company, ideally 10 or more. They've gotten more and more strict lately about that. Again, 10 years ago, we would have clients filing, they might have 2 employees at the US company, maybe 3, and it was going through. Those days are gone. You need 8 or more employees. At least 2 of those employees need to be managers, and ideally, those 2 managers have a higher education. We've had cases get through where the managers under the applicant did not have a higher degree, and they got approved, but I think it's risky. So we always tell our clients, your immediate subordinates, your immediate managers under you in the US should have a higher degree, and then they oversee the other people below that. But again, same general rules apply for the US position. You've got to show that if this is a case of a new US company, that in a year, that you will be managing 8 or more people, that you have extensive job duties that cover all the oversight and management of the main operations of the company. You have the ability to hire and fire people, et cetera, et cetera. So those are really what they look at. So again, these are not the only reasons why you might get a denial for an L1, but I think these are the 2 top reasons why you might. And so this is what you need to focus on when you're preparing your L1 petition. If If you have any questions about L1 or even other business visas, feel free to reach out to us directly or leave some comments or questions below, and we'll be happy to answer any questions you might have.